Appeals meeting. This meeting, it's not a public hearing today. The board is working on discussions about their rules and procedure. So being it's a public meeting, we are going to record today. But just a little bit, board members, tell you, this is an update of our rules. The current rules that we operate under were adopted in 2019. This is a cleanup both in format of the board's rules. There's some typographical errors that are a little embarrassing in the prior one. But there were portions of rules that really fit together in the same section, but they were scattered about through the code. So if you've looked at any of our changes, Ann and I really worked to try to get them all in the same place. And we've received some comments from you guys, from two of the members, but just wanted to kind of go over a little bit. If there's anything you want to alter or add, now's the time to tell us. There may be some portions of these rules we can't change because it's statutorily based.
So Joey, because I'm clumsy with redlining and my assistant was out, I made a few changes, handwritten. You said you want to, if there was others, you want to hear about them now.
Yeah,
but
absolutely.
I was going to wait until we got to those.
Okay.
Particular
No, that sounds fine, and I'll take your copy
Okay.
when we're done and keep it on file with the board's documents for today's meeting for if the public wishes to view them.
Yeah, and I was going to suggest really, I think the most straightforward thing to do is just to go through it section by section and just one bit at a time. And I know some of you have circulated comments already, and that's terrific. Some of you might just have comments you want to add in now. That's also terrific. And that this is kind of like a first go around with these rules because there are a lot of changes proposed. And it was really, as Joey said, a lot of it was just kind of like cleanup and reorganization. That was like a large part of it. And then like taking out some material that we thought wasn't appropriate regarding like the home daycare that really didn't need to be in the rules. And so this is just a time to like first go around with this. I mean, if you feel like you need to, there can be like an additional session like this, maybe one that would be shorter, just to work through some additional issues if there are some outstanding questions. And, it's your process and your rules, and we'll take our cues from you.
Yeah, and really, it just kind of, based on that sort of beginning, the first two sections are just preamble, the purpose of these rules and what authority you have to set down the rules. But really, the first substantive change I'd suggested is in Section 3. It deals with officers, both the chair and vice chair. We had in our rules set for those elections to occur in May. I was only suggesting a December, so it's at the end of the year, and we'd start our first meeting in January with new chair and vice chair. But that was just only my suggestion. We can do a election of officers anytime. I think since I've been back, we've not done, we've just kind of status quo kept going. And the reason I wanted to keep that was knowing we were going to change these. So that was the kind of time, and just get a feel from you guys as a board, is May fine? Would you prefer a different time of year to do elections for chair and vice chair? Even if it's just, we should hold these, if it's just, hey, we're going to keep the chair and vice chair as is, that's fine. But we should be doing these the same time each year. And it's the general practice for boards of zoning appeals.
I think December seems like the only reason I would say it seems like a good option is if you have new members who rotate on in that February, March range, whenever the periods come up, it gives people like a little bit of runway to kind of understand before voting to elect a new chair. Not that, I'm suggesting any sort of efforts to topple Mr. Pepper and Ms. Carbonek here.
You can topple me.
But it seems like it would give people sort of time to kind of get used to the way things go. But I don't have a strong opinion.
Do you traditionally have a good attendance kind of quorum around? I think the first one in December is usually pretty good.
Yeah, if the BZA is coming up December 23rd, we'll generally can that meeting just administratively, knowing that we're not going to have attendance, both from the public or you guys. So there are times at which, if I've got a board of zoning appeals July 3rd, we're probably not holding that meeting. But I take care of that on the front end and just, hey, all these cases will shift. But unless we get into a situation, and that's something we look at, if we have a significant number of cases, more than one or two, then yeah, let's have a meeting, even though it is the day before a holiday. But historically, what you think would happen does happen. People don't file because they're like, well, we'll just wait till after the 4th, or we'll wait till after Christmas to file. So it's sort of cyclical anyway. But if we do that, we would do that at in the first meeting of December of each year. If no one feels strongly one way or the other, we'll write that in our version to change this to December, and we'll start this coming on that. Next sort of note or associated note was in section 4 about applications.
So before, okay.
Yeah, or if you've gotten any other
Yeah, I've got
in
some.
section 3.
I've got some in 4C1, which is really about submittals. I think you're going to 4E, correct?
Yeah, I was just looking at 4 in general,
Okay.
just to
Well,
talk about.
I don't want to jump in too soon.
No.
Okay.
Anything in 4. The first little comment that we had was in 4B, and Peyton's comments were about as far as do we require these. This is to get before you. Someone has to make an application for a building permit, and they've sat down with an examiner first to kind of go over. And for most people, it's design professionals. They know they've got a variance in some sort, but the examiner's looking to make sure there's not something else. And then they come sit down with both either Christy, Tamika, or myself when they file this appeal, and we go over it with them to see. And then we do an internal check after we close the docket and just look through everything like, oh, we missed this variance. Let's add it before we advertise it. Well, we can always over-advertise a case and peel off, but I can't miss something and keep it on the agenda. So we've got sort of 3 steps in our process to go over those before they get here. And this section, all of section 4, sort of in my prior time with the board, this board used to just accept rough drawings on the back of a cereal box. I mean, so we've really required more information. We went to paper for a while, 8 sets of 11 by 17 to scale. I think it was altered and amended before I left in 2015 to allow PDF submissions, but this is just for y'all. I want to make sure that you guys get what you need in the submission packets, or at least in the process before we get to the day of, so you've had a chance to see what you need to see. Understanding that other stuff can flesh out after testimony.
So my suggestion was because we've had some cases, I mean, right now, the way the rule is written, I'm looking at 4, and by the way, there are 2 4s. There's 4 application and 4 res judicata.
Oh, yeah. There you go.
So I'm on 4 application, then so it'd be 4C2, site plans for uses other than 1 or 2 family residential and daycare homes shall be drawn to an engineer scale and be of professional quality. I think there are some cases where we've had a single residence and we really couldn't do much with it because we didn't have a good site plan or we didn't have a good survey, and that wastes their time and our time, because I remember one recently, it was the one out on Highway 100 where the first time the applicant came up, we said, look, we need to see a survey, and it was a single family residence. So what I've suggested is, what we have now in 2 is site plans for uses other than 1 or 2 family residential and daycare homes shall be drawn to an engineer scale and be of professional quality, period. And then this is what I've suggested adding. Applicants whose property is a 1 or 2 family residential property or daycare home are encouraged to consider whether the decision on their application would be more efficient with a site plan drawn to an engineer's scale and of professional quality, period. And then I've also suggested that we add a number 4 to that subsection E, because we've also had some cases where we've sent people back to get boundary lines. And sometimes they're single family residentials, but we can't tell whether they draw in a crude, they say, well, the shed's here. And we think, well, we really can't make a decision until we know whether it's 8 feet or 6 feet. So I've suggested a number 4, applicant should consider whether a boundary and/or boundary and site-built survey prepared by a licensed surveyor would aid in the resolution of their matter. So, for what that's worth. And I also think in section F below, where we have, they may present to the board materials essentially the day of the hearing by providing 9 copies. I might want to insert 9 paper copies, because we have had people come up before and say, I've got this on my phone. But those are my suggestions with respect to the application. And I can give you these in writing, Joey,
Okay.
and I can read them again if anybody wants to hear them again. I'm glad to do that. And I apologize, but
No, that's
it's beyond me to use a redlining. It would have been a nightmare.
Yeah, same, Mr. Pepper. Yeah, I can tell you a little bit, just sort of the history behind that number 2 of site plans. That it was hearkening to where we didn't, if we're talking contractors here in front of you that's drawn from a building permit, what really should be happening is my folks in office should be requiring professionally drawn drawings that come to you. Just to give you, I've been doing this since 97, so give you some, it was, the board sort of held contractors to a higher standard of submittal than we did just John Q. Citizen who wanted to build a little shed or something. Even now, though, the code has altered, has changed so much since those early days that we really are requiring them more detailed plans. Maybe not necessarily surveys, but those 2 examples that you brought up are like, we had the fence on Old Hickory Boulevard. We didn't know, the fence looks like it's 10 feet from the pavement, but it's actually in the right of way. Those are things that probably I'll do a better job on my end, not bringing to you until we have some definitive one way or the other.
And the only thing I would say that if we were to do that is to create some, and maybe your sort of, if it aids would help, but, if it's a 2 foot beyond the 6 foot variance on a porch that's, a single person that's wanting to add an extension onto a porch or something that's really minor or minimal that maybe they don't really need to go through that expense and process.
Yeah, and I don't, my hope was by just saying encourage that would at least start a conversation with y'all, and they'd say, because I don't want, you're right, we don't want somebody to spend $2,000 to do a boundary line survey because it's a 2 foot variance. So that's why I didn't make it mandatory. And if y'all are, it may not be needed if y'all are handling it basically before it gets to us. But I know over the years we've had several cases where we've had to send people back just because they got some kind of crude hand drawing and it.
And I'd rather. And no, I think your changes are a good idea. I think that's something that I can do better on my end.
Sorry.
On the submittal side of.
Yes, I was saying, do you want there to be something in the rules in effect to leave that to the discretion of an zoning examiner as to whether or not those materials would be necessary?
Yeah.
Do you want to have that kind of preliminary level of screening as to what they're going to need to bring something before you that you can actually work with?
Yeah.
Is that what I'm hearing?
Keeping them from having to come back.
Yeah, exactly, because that wastes everybody's time. Yeah.
We're waving.
Yeah.
You go first.
I think that would be good. I mean, you don't want to force them to incur costs, right? But we are making permanent decisions, and we've had, this leaves it ambiguous. An engineer's scale of professional quality, you could use graph paper and put that together. It's not necessarily a licensed surveyor, right? So yeah, I mean, if we're making calls on boundaries and variances, I think you have to have somebody that's a licensed surveyor or something, right? But you don't want to also have it everybody be required because they could spend thousands of dollars. But I think putting it in your hands or your reviewer's hands, Joey, like Ann said, would give us the correct information. We had one lady too recently come, she drew the shed in the back with a hand sketch and took a picture and said it's 3 feet away, and we couldn't even figure out. So we were giving these, in a sense, permanent variances.
I recall that case, we ultimately ended up dismissing it because her survey proved that she complied. She didn't need a variance. I dismissed that at the last hearing. After it was all said and done, she was fine. And maybe too, we can in letter D sort of merge those 2 together, just saying, hey, the staff for the board, which will be by ordinance is me, but it's the folks' work for me to be sure that it's it has enough specificity, it's clear enough for you guys to be able to make a decision on it. It's not ambiguous, I understand. I'm getting the gist of what you guys are wanting out of that.
I still think the final decision on what is presented to us is up to us. If we need more information, we should have the right to ask for that information and not have the applicants feel slighted because they already went to the zoning examiner and it got passed by the zoning examiner. Sometimes we need more information and it comes up during the meeting. So
That's
if
true.
there's something that could be, the board has the final decision on what needs to be shown, something, I don't have the right language. But
Okay.
You understand.
Yeah, so I see how some language could be added to, tweaking some of the language under C and then in D to kind of make it clear that the zoning examiner, I'm assuming, would make a preliminary determination as to what materials will be necessary in a given case. And then of course, the BZA can
Board
always
reserves the
require.
right to,
Yes.
Yeah,
ask
yeah.
for more. Because I think too, opposition sometimes will raise an issue and we may go, oh, that's an interesting thing to think about and want to see something in conjunction with it. But I do think that the pre-clearance thing would, because the thing I think about are the people who have to come back 2 or 3 times because of different things and it's expensive, they have to take time off work, opposition has to take time off work, they have to organize, it's just whatever can make it to where they show up once and a decision is rendered and then they're done.
And this is moderately off topic, but I want to bring it up so I don't forget. This is something I brought up a while back, and this may be a little too granular, but, we talked about the wind and light study when people come and they're not presenting high noon on July where there's no shadow. I don't know if that's another part of this or something, but maybe picking a couple times a year and days where actually you're getting a realistic shadow study. Not sure how much that ultimately matters.
Sure. No, that's something that I'm happy to handle in-house.
Okay.
I think that, to your point, there's no shadow. Of course, there's not. The sun's directly on the
Yeah, exactly.
That's not the point of the code. The code is, hey, at 4 p.m.
I remember that one that came in here. I remember
Yeah.
looking it up online, and it was the sun was
High noon, yeah.
Yeah. It was,
So-
Or the traffic study on Christmas Day, right?
Right,
Yeah.
right. Yeah, we've had that where it's, we're gonna need, okay. No, that's fair. I follow where you guys are coming from. E and F more talked about. E evolved out of, I don't know, Ross or Christine, y'all may remember a time where principally it was opposition, would show up with this huge binder of stuff the day of the meeting and wanting y'all to look at it. And there's no, So E sort of evolved hey, if you want this board to look at it, you got to get it in by X. And X was decided by a prior board that, hey, Thursday by end of businesses, that's it. You're welcome to bring it to the meeting, but the board could say, yeah, we're not accepting this. This is.
I think Ms. Johnson's suggestion of the Tuesday before was pretty good. I like that idea.
Yeah, I
Tuesday
think
week
it's
of.
Yeah.
reasonable,
like-
still give us enough time to review, but Wednesday or Thursday morning, because of our busy schedule and other professional, occupation, we may not have time to review it if after Tuesday, end of the business day. So it seems like kind of good compromise to me.
But doesn't someone have to intake that and then get it back to us?
Yeah, we'll get it, and I'm taking a class this week on our SharePoint site, so yeah. I'll make
I'm
sure.
just making sure that's really enough time for.
To make sure y'all have it.
Is that
I'm also
not-
working with ITS on getting things out on website. It's always, in this modern day, you want everything on a website. Well, that's great, but realistically, there's just not enough people to do it in time. Our doors are always open, so if somebody wants to walk in, this is kind of for folks, if they're watching, you're welcome to come down, see me, my staff, we'll show you whatever you want to see, make copies. I don't always have it. We've got the stuff required by law. We try to put more than the law, the docket, the submit to the Plan Commission. One of my goals this year is more information to the website for the public, for y'all, save phone calls in, asking questions. So I'm working on that, just sort of outside anyway. But I think providing some place for people to see a link Now I got to work with the IT guys on how do we get stuff from a Dropbox shared to a public space, and not let that be a means of uploading stuff that our IT folks don't want uploaded into our network. So, but yeah, no, that's part of the goal too, is make sure that you guys have it. It'll just be incumbent on, hey, Wednesday morning, I need to go look at the SharePoint site, and here's everything that's out there that we've got as of Wednesday morning. And then for us, stuff we get in, we have a folder.
Would it make a difference to have things due by noon on Tuesday as opposed to close of business, which would give people time on Tuesday afternoon to get it uploaded?
Well, end of business for me is just easy. We're not here. So if it's email, that's good. We just always found that even our filing deadlines of noon, it's not a hard noon. I mean, because somebody roll in there at 12:30, and we just always sort of operated informally, like, hey, as long as you're here, if deadline's Tuesday, as long as you're here Tuesday, we're good, or you've emailed it on Tuesday, you're in.
I guess I'm just trying to figure out if the goal is that you'd have them by Tuesday night, or if it's okay to have them Wednesday morning. What do people want?
I mean, I think
That's a good point. Yeah.
I think Wednesday morning is probably fine, just because, I mean, if it's the application itself should be in before then, the primary bulk of documents. I'm thinking if it's opposition, correspondence, emails, I mean, sometimes opposition files are 100 copies of the same letter that's been signed by, every neighbor on the street, just repeated. Sometimes they're, long-winded things that contribute nothing. Sometimes they're meaningful. And so I think, it's hard to know what the volume or breadth is going to be, but I think in terms of, having it by Wednesday morning will give us a good flavor of what the contents are.
What's the rationale from pushing it up from the Thursday before?
I think
Why are we changing these changes?
I think it was just.
Yeah, sometimes, Thursday before the meeting, so week prior to our meeting, sometimes agenda does not published. Agenda itself does not publish Friday prior to our meeting. So Friday, and then, so require opposition or comment the day before agenda is published will be unrealistic to me. And sometimes agenda will not be published until Monday because, requirement to notification is 300 feet or 500 feet, surrounding area. Sometimes neighbor will not get the notification because they are within that, notification requirement area. But even though outside, oh my gosh, this change is coming, it really affect my property, good or bad. So if that's the case, we want to hear, I think. So that's why I think it's kind of reasonable to extend the, comment, particularly opposition, or even, supporter or applicant sometimes forget the important information. So give a little bit, extension, because the main application will be there by Thursday or a certain date. And, Joey will be getting chunk of document. But sometimes, they may forget one piece of critical information. So if they can add and we can weigh prior to our meeting on Thursday, I think that would be beneficial for applicant and as well as us as information.
Yeah, I could speak to the whys at Thursday. It goes back to the days we didn't put together a PDF. I literally staff printed it. I came to you, I showed up at your office and here's all the documents for this meeting, physically delivered them to you. So I needed time. That now that we're electronic, shifting. That's fine. I'll be sure. Agenda should be published pretty early. Now they might change. Hey, this case chose to defer, or they withdrew. I want to make sure, I'm working with Christian to make sure when those changes happen, let's get it changed and uploaded. I don't know how our website lets you know, oh, this is new, or whether there's some graphic on our website that says this is updated as of such and such. One change I can affect on that is just making sure that we put that date this agenda is valid as of this time, and then we'll publish a new one and change the dates on them. But the goal is, as soon as we close that docket, we know these cases are going to the board. There's at least an agenda published of here's all the cases filed. Now, some of those could fall out, but we would update along the way. And then 2F's kind of the catch-all. If it's like, oh, it's Tuesday and here I am Wednesday and I thought of this great exhibit. Great, just bring it to the board and let them decide if they want to accept it. It's not, because it may be germane, or if you don't want somebody dragging this cart full of documents, day of the hearing. That was what this whole section was about. Prior boards would just get slammed with all these documents and expect them to read it day of. That's just
And I do recall, I think, a billboard case where we had a demonstrative exhibit that was intended to be a, replica of a billboard. That the size and scope of the thing was was the point. And so, in those circumstances,
Sure.
people show up with that kind of stuff.
Okay. If you guys are comfortable with making that change to the Tuesday week of the board meeting, that's no problem. We can make that happen. And we'll be sure on my end that we get both the SharePoint site updated, but for sure the front-facing information to the public as far as the correct. That day will also kind of correspond in my mind. That is sort of our final draft of the agenda. It could change day of because somebody comes in and goes, oh, I didn't realize I had 100 people showing up. Can I defer? Sure. We'll let people defer once usually without having to ask you guys to do it.
I think the agendas are posted well in advance, though.
Yeah.
I subscribe to Nashville.gov, and I pick on what I want to subscribe to and when is the BZA. And so on February 20th, just looking at old emails, I got the agenda for the March 6th meeting, so it seems like you guys do put them out there in advance.
We do. They should be getting published. Yeah, there shouldn't be any reason, at least there's not preliminary. I would like to add some stuff to what we post. Not required, but I think may save some phone calls to our staff. Hey,
So they're available on the website well in advance of our meetings?
Yes.
Okay.
Oh, yeah. The agenda definitely meets the statutory requirements of notification. Like, for instance, to give you an example of one item, like the public hearing signs that the applicants put up have to be up 21 days prior. Now, that's not to say I haven't seen instances where vigorous opposition goes out there and rips it up, takes it up. So what I usually do when I go shoot photographs for your case, I go on that 21st day to make sure that, hey, your sign's up on the day it's supposed to be up. And if it's not up, there's a valid explanation. Now, the opposition taking down signs is rare, very rare, but I have seen it. But I've also seen it where the applicant just forgot to put the sign up. And so you guys never saw it, but I kicked that, it'll all of a sudden on your end, it says deferred to the next meeting. Well, I don't give you the why, but sometimes they didn't post their sign on time. So I'll go out there on day 21 and that sign better be up. If it's not, I'm knocking on the door like, hey, what's up? Oh, I've got it right here, or oh, I didn't get it printed. Well, I have to move you. So we make sure that happens. The mail notices go out before that. So as far as notification, the mail notice goes first, then the sign comes out. But both those are required by ordinance to be posted. Okay, good deal. Oh, yeah. There's a clean. Oh, yeah, sorry about that. Uh-oh. Yeah, flip over there.
I think right now we're at the end of the first number 4. The application.
Okay.
Were you done with that section?
Yeah, and one thing I was
Yeah, if you got any other.
there were some tiny little things that I stuck in there. I was just gonna figure things like changing letters, email to just correspondence or something
Yeah, we'll clean that portion up. Res judicata, the 6 months of coming back to this board, that's not waivable by you guys because it's in the ordinance calls out for if there's a denial of a case, they can't pursue similar or the same or similar application in the code. It's in 1740 in the 400s, where it talks about under the board, you just can't. Now, we've been pretty general with that, or liberal with that, to say, okay, great, the board can't hear it within 6 months, so that doesn't mean you can't file it 4 months out, knowing it'll track and be inside the window of being back in front of y'all properly. We'll try to do that as soon as we can. Or if in an instance where we have a case where we've made a mistake in the permit, we shouldn't have issued it, or we made a mistake on setbacks, we will handle notification and putting up signs and put them on an agenda earlier than they would have normally tracked, just because that was our fault. And then A and B is really the same. It talks about variances and special exceptions specifically in the code. Letter B, we added, well, if we're doing that for those types of appeals, then that should be true of changes to item D appeals or changes to non-conforming uses or structures. And we'll correct the numbering. C was one like, hey, and we haven't had this. This goes back a long way. But before we had that in the ordinance, we'd have somebody get denied and then immediately file for a new variance because y'all voted no. And then, they're back here 4 weeks later asking for the same thing. And so C just sort of says, we can disallow you filing any new cases because there's nothing new here. You just keep asking for the same thing and you've presented no new testimony or anything. We can leave it. We can toss it. It's not commonly occurring. More on that. Any other items on the first or second number 4? We'll get that on 4A and 4B right now. Okay. One I want to touch on just for myself, and then you guys are welcome to jump in. Conflict of interest section. This is something we get questions. Is this a conflict? Nashville has not reached the size yet. It is the largest small city in America. We've all, as design professionals, lawyers, architects, we've worked with somebody that comes here. So there's no avoiding it. The key part for me is, hey, if you're unsure, just disclose, hey, I actually worked with George on a project just recently, but I feel like I can hear this case thing and offer it up to I'm happy to hear it, but unless somebody wants me to recuse myself or feels they can't, but I'm just disclosing, this occurred. Obviously, if your company has an interest in the project, you're out. All thing to do, just come to me, hey, I can't hear this case. My firm's doing the drawings for this, or, my law firm represented them in the zone change that got them here. That's probably a no.
One question I had on that is if it's the client versus the representative, right? Because really the lawyer or the engineer is sort of an arm of whoever is seeking the relief before the board. So it's sort of, I think that if it's somebody who say, you've worked on something with in another setting that's a lawyer, but that lawyer's representing a different client, then that wouldn't really be a conflict.
No, because the thing is, it talks about direct or indirect interest in this property in front of the board.
Yeah.
This thing, not something.
Right.
What's in front of the board? I not long after I came back here, one of my clients came to y'all and I was like, I'll just step out of the room. Even though I didn't have I felt like as a lawyer, I had an ethical duty to step out of the room. Even though I don't influence y'all's decision. I just didn't feel comfortable with being in the room when they presented their case because I did represent them on the very thing they were here in front of you for. But I think that's the part. B talks about, and Ann can speak to it if she like too, the code section of the Metro Code laws is 2.222. There's all twos. And it talks about, having an interest or what is that type of thing. I do recommend you go look at that and read that section.
Okay.
It's fairly straightforward, and it does talk about some other stuff outside of your board thing. I guess last thing for me, C is ex parte contact. You've got a case or somebody reaches out to you and, hey, I need to file an appeal with the Board of Zoning Appeals. Just forward that email to me. Don't comment to them. Just say, hey, I appreciate that. I can't discuss this with you, but Joey can help you, and send it to me. Or if I get an email, I'll see that. I'll just reach out to him and say, well, unfortunately, he can't really talk to you about this, but I can. I'm happy to do that. Or if you know of a case that's contentious and you go to church with somebody that, is really upset about the case, I'm sorry, I appreciate you. I can't really talk to you about this case when it's in front of the board. And that period includes the time it's available for appeal too. So it's 60 days even after y'all have made a decision. There's a window that they can appeal. You really shouldn't comment on those cases either. Any of those, any questions like that come to you, direct them to us and me, principally me, I'd say, my staff. But just try to avoid anything like that. I've told my staff to be sure when they send y'all emails that you're receiving emails from us and that you're listed as a blind copy. So we can't have reply to alls accidentally and y'all are communicating via email through that, those types of things. But
And ideally, all this information is going to be in the packet also, right?
yes.
On conflict of interest, I mean, I, for whatever reason, happen to know a lot of people, so there have been people that have come in front of this board that I know personally, but I have no interest in their case. I mean, I haven't said anything, but should I say, I know this party, but I have no conflict, or should I not address it at all?
I think it's always better to disclose if it's, especially if it's someone that you know fairly well, and have dealt with kind of recently. I think it's, better to err on the side of disclosure. That would be my 2 cents on that.
Okay.
Like I said, there's no avoiding in y'all's world as builders or design professionals. There's just too much. This town's not big enough. You're gonna interact at some point. But the key part of it is like it talks about in A, this, which is the subject matter of this discussion for the boards. And I tell you how members in the past have done and say, hey, just FYI, this person was a builder and like, hey, I've used his firm before to do projects for me, but I don't have anything going on with him on this project, but I do want to disclose that we've used that. So if anybody feels
Just kind of airing it out.
amongst the board, hey, do y'all feel I shouldn't? But at least you disclose it. Ann's right, disclosure is always the better thing. Yeah.
Okay.
And I'll tell you something that's kind of, I learned, and it's a thank you to Joey, because one time there was an applicant up here, and it happened to have been just a client I had just finished representing, and this client had paid a bunch of money to me. And as soon as I said, oh, I know you, I've got to recuse myself, I thought that person looked like, what? You don't get to hear this? And so I had Joey come back and put on the record essentially that I said, Joey, I clearly can't hear this. And he came back and kind of said, kind of cleared that up. So the reason I say that, it made it easier on me, because I was really concerned about, and it could happen with a friend, it could happen with whatever, that it looked like, well, I'm just bowing out. But it really helped for you to do that. So.
Yeah, and well, on the other side too, and I've seen it, I've been to hearings where there's clearly something's going on, and I won't name jurisdictions in the state, but I've seen it where there's clearly been a conversation between a member of a planning commission in opposition to my client's case. There just had to be. There's no way this member could have known what they were sitting there spitting out in public hearing, but for an outside conversation. But it just looks bad to opposition or to the public in general if, well, of course, Mr. Pepper voted for it. Hey, he's their lawyer. I mean, it just looks bad. There's no conflict there. I mean, that particular instance had nothing to do with what was in front of the board. But it's good to err on that side because it was so recent enough.
Yeah,
where it's the appearance of something wrong that's really makes it worse than the actual conflict. To that end, let me tell you and I won't name the city, but it is in Middle Tennessee, where Plan Commission members went to the site and visited with my client. We don't go to the site. We don't do site visits. Now, you're welcome to go to a site visit, but go individually. We're not going as a group. They went, 3 commissioners piled in a car and drove to the site.
Hello, Open Meetings Act.
Yeah, that's a real problem. Strangely enough, their city attorney didn't feel it was a very big problem. I'm like, well, gonna disclose, here's my opinions on it. So I, at the hearing, said, I think that's improper and you guys should recuse yourselves. So, even though they were probably yes votes. So, anyway, it worked out in the end. They did recuse themselves and the thing passed anyway, but it's just bad. Just, like I said, that is actually bad. But you just want to avoid the appearance of something on there. Was there anything in this section you guys wanted to check? Always, if you get an email or something, shoot me or Ann an email and say, hey, here's what's happened. My advice is don't even reply to it. Just forward it to me and we'll deal with it.
If I've ever had people ask about anything related to anything that would come before this board, I have your contact card saved in my phone, and I literally just forward it to them.
There you go. Section notice, under notice requirements. Hey, you got to comply with the zoning code, obviously. B was, I think we had a comment from one board member of as far as notifying council members. That evolved over time. It used to be we sent all of the cases to the council staff and they distributed it to the council members, here it was, and then it got a little more. Then the next mayor didn't want that, or I don't know what happened. But long and short, we put it back in the rules years ago. That is just a good idea that the council member knows what's going on in their district. We don't have to, but y'all choose to, and you chose to in your rules. So we kind of put that burden on the applicant. Hey, be sure to reach out. But we are also notifying the council member. We sometimes have council members who forget that they were notified by us, but. And then C was something that's really important. It evolved out. The board did not have this requirement for many, many years about holding a community meeting for special exceptions. This board started requiring it. We had a case up in Jolton where the applicant didn't, and the board went ahead and held the meeting anyway, and the neighbor sued, and the judge said, nope, that's invalid. They didn't hold their neighborhood meeting, so the board didn't even have subject matter jurisdiction on this case until that public hearing, until that neighborhood meeting. So one of the things my staff and I do is make sure they've held their neighborhood meeting before they're not going to sit on this table and talk to you until that neighborhood meeting's happen. And you guys put some things, hey, it needs to be geographically convenient. You can't go meeting in Bellevue if your case is in Antioch. It needs to be somewhere near the site. And you put in some guidelines about what you need, what you'd like to see at that. And I'll tell you, we advise the applicants to work with the council member to hold that neighborhood meeting. But as I've told some council members, that is not mandatory. What we don't want the council members having is sort of control of the applicant's case. Like they can't get to you until they come through them as a council member to hold the neighborhood meeting. That's not how this works. If the applicant wants to hold their neighborhood meeting outside the council member, it's fine with us. You're meeting the thing. But the council members really should work with applicants on, working them into that monthly meeting. That works. As so long as that applicant notifies the same people that they notified to attend this hearing, the same mill list is supposed to be used, not just, well, I was on, Councilmember Smith's community meeting. That's not notice enough. You've got to send out those letters and tell somebody that you're going to be on that neighborhood agenda. Was there anything you guys want to add to 6 or notifications? Was that good? Okay. Procedure sections just, what does it talk about? What's a quorum? These are all some boilerplate stuff that have to be to meet all the Open Meetings Act and such. All this is going to be in here. The Metro Code actually says that the board can tell me to subpoena witnesses to bring documents or books.
I'm going to find a way to do that someday.
I've done it once. I drafted this subpoena thing and let legal and them go, yeah, it looks good to us. And I signed it and had a notary in my office stamp it and
if we had a show cause, that would probably be something that would end up, if it was, we're having a show cause, we need to compel the attendance of whoever
Now this is not compelling attendance of outside parties. These are internal Metro people is where this section comes in. witnesses that are needed, the code talks about metro parties, but I mean, we can say, hey, this person is such important part of the case, they really need to be here. I don't think I've got the force and effect of go getting the sheriff to make them come, but we've never had it, but it's just kind of the goal is, hey, and you know, if there's information that NDOT has that really y'all need to know, like, hey, NDOT, I really need you here. But y'all have accomplished that same goal on its own, but just like, well, we're deferring it because they're not here, you know. Let's see here. G, witnesses under Board of Zoning Appeals here are not under oath. In North Carolina, you are under oath. It's the full rules of court. It's cross-examination, examination. You're just not. That Tennessee case law is like, no, you're a quasi-judicial body, and they really keep you at quasi on this. But other states you're more judicial than you're not.
Yeah, my main concern is on this was the sort of comment that, you know, if it determines that false information is presented, the board has a right to reconsider its decision. How do we communicate that?
I do that every meeting
Okay,
at the beginning of the meeting in
yeah.
my notes. I'll be sure we cover those types of things like the right to appeal, you know.
Yep.
If all that's covered in there. And I think the wording I use, if it's found that witnesses or applicants have presented false or misleading testimony, we've had that once or twice in the past where the applicant just flat lied to you and showed you one drawing, or usually there's a special exception. Y'all put some condition on it. The case I'm thinking about, you know, if there was hours of operation and you could do it so many days a week, and they were just doing it all 7 days and just blowing through, you know, just ignoring conditions. They lied to you on their thing. So basically what we do is a show cause hearing, bring them back to this board and let them explain, all right, why are you doing what the board told you not to? And the board can revoke their approval after testimony and hearing. Let's see. Hearing part, Ms. Johnson, you had a question about as far as statements from elected officials. The board put this in there. Like when you were council, you know, you've got a committee meeting at 3:00 and you really need to be there. We start at 1. That member, when they come up and I ask, are there any council persons here wish to address the board? You all allowed council members to kind of come out of turn, put their testimony on the record for the particular case they're interested in, and it is part of the record. You don't formally open the public hearing, but it's understood both in our submittals to the courts that this is part of testimony to their statements. And that way they can get on the record what they want to say and attend their whatever they got to do, rather than, you know, if their constituent's case is the last case on the agenda and it's going to be 2 or 3 hours. But it is considered. They're not limited to just at the beginning. They can wait. And you may have seen it, or maybe you hadn't, you know, asked, do you want to talk now or in the case? And they're like, no, I'll wait till the case. That's fine. The only thing I would ask you guys to be careful on in that is you've closed the public hearing. Now the council member wants to talk. They need to be on the record. They are in the preliminary stage, but if, you know, we've had the applicant and opposition do their thing and you've closed it, the council member's chance to talk was then.
And does the 10 minutes count? I think we've always
We have not charged the council
10
member.
minutes, and it's not in the rules, but I've always thought that, because what I've seen happen before is the applicant talks, the opposition talks, the applicant talks, and then the council person gets up and talks because they don't have a time, they talk for 5 or 10 minutes. And the appearance to the opposition that we've always tried, I think, to say, ask the opposition, you know, give them a chance to speak too, because I think just the appearance of somebody getting a lot more time and getting the last word. And that's all. I don't think we need to change the rule. I'm just saying I've always thought that was kind of incumbent upon us to make that offer.
I think we should change the rule. I think we should remove the council member ability to speak at the beginning of the meeting. And I think that the council member's time needs to be counted either with the opposition or the support of it. There's nothing in the code, there's nothing in state law that gives council members any special authority over what board members, over any other member of the public. I feel like we have seen an increase in some council members who come and sort of take a neutral, just the facts approach to these. Some put themselves in the position of, as the chairman said, Mr., extra advocate. I think it's unfair when a council member can put their hand on the scale in that manner, and that the rules authorize that. So my opinion is that a council member's support can be lodged, or opposition can be, lodged through a letter or an email, but that if they're going to speak on a case, unless they're going to not take a position, which I don't know how you would gatekeep that. I think that if they're going to be speaking in support or in opposition, that it shouldn't be at the beginning, and it should be part of the time that the support or the opposition has.
And I would wholeheartedly agree with that. We've managed to do it by, I think, just giving the opposition a chance to speak. If they speak, where I've seen it is they get up and speak last, and then they take the last 10 minutes, and there's no time. I would be in support of that. We've been able to manage it, but I mean, I agree. The appearance of it just doesn't come. It looks like we're giving more deference to the council person than we are to the other people, and I do. I mean, I don't think we have to make the change.
I have a little concern because I understand. I think it's a great policy to be fair for supporter and opposition. So, council member, in case council member has specific opinion on either support or opposition, they can weigh in extra. But sometimes, council member, as a part of the constituent service, they may show up. But knowing, if the case applicant is asking for the approval, and she or he may feel wanna be approved, but knowing the regulation and cause, it won't be approved. But, she or he may be here to just advocate for their constituent. In that case, she or he may not be able to stay oppose or support. So I think, with that rare case, it would be good to give like a courtesy to have, as a part of a constituent service and as a part of representing their, constituent.
And I'm saying if somebody says they're neutral, is that what you're saying?
Yeah.
Sometimes,
they have said that in the past. They have stood up and said, I'm not here for or against anybody. I just want to point out, and I don't think I don't have an issue.
Yeah.
If they're neutral, I'm fine with
my council member, my former district council member for a long time took the position of he came and he never said, please support this, please oppose this. He took these are my observations about this, and I know there's some now who do that. And frankly, I always really appreciate that because I think it recognizes the board's sort of independent authority under state law. There are council members who get more heavy-handed. There are council members who take personal offense to things this board has done. And I think that if we, I think it really puts the onus on what's the council members' role in this, and because in the same sense, they may be doing a constituent service because they have folks who are opposed to a particular project in a neighborhood. They also have folks who are seeking to develop a project in their neighborhood that might add constituents to where they live or create a new opportunity. So I think fundamentally there's, when you have two sides to a project within one council district, you have two potential opinions that are going to affect the same member. So, I would say I'd be fine with giving them that ability to speak before the meeting, but, restricting it to not taking a position in support or in opposition, and that if a council member is going to take a position, support or oppose a case, that needs to be done in writing, or it needs to occur as part of the support of the opposition of the principal case.
they're 10-minute.
Yeah, so it's if the council member is saying, I encourage you to approve this, or, please oppose this, where they're the cheerleading advocate against the case, that needs to be part of the main presentation.
Yeah, I would agree with that, and I'm fine. I think every council person that ever has stood up and said, I'm neutral, I think they have been neutral. I've never gotten the sense that anybody's ever stood up and said, I'm here just to give you some facts, and I'm not for or against either side. It may have happened, but I don't think that it has. And I think that if they declare they're neutral, then I think they may have something, as Mina said, to add about the neighborhood. They may have insights we don't have, but I agree with Mr. Bradford. I just think that we have managed, it hasn't been a big deal because we've been able to manage it it doesn't happen that frequently, and we've been able to manage it by offering the opposition a chance to speak again, but I would support that.
Seems like that's a big change, though, because currently we do have, because elected official, we do have a courtesy, same as planning commission. They can speak in the beginning of the meeting or with the case, so they do have choice. And I think because of their nature, elected and representing the specific district, so they do have information pertaining to the specific location or case. So I think a current practice, giving courtesy seems like reasonable approach than changing to either have the council member speak, either support or opposition within the time limit.
I think
it's a kind of bit drastic change.
The only difference, though, I would say with planning is that if it's a rezoning, that has to go before council for approval. I mean, our decisions are, it's a decision of the zoning administrator, or and then from here, you're going to court. It's not going to council. So, I mean, that's where I think, a council member's views on something, I think, do carry more and should carry more weight in a planning decision because it's something that ultimately is going to be before the council to approve. So they have to be on board, or the record has to be clear where they stand on it. I mean, I think here it's, frankly, the cases, the code says what the code says. We have to consider the council member's position isn't among the list of things. The council member can come in and articulate their opinion about, whether a particular provision of the code applies or doesn't apply. A lot of times that's not what happens. And I do see the value in somebody coming in and explaining, this is the sort of circumstances around this entire neighborhood or this project, and here's some more background information to furnish. I trust you to do your job and make the decision, but I feel like it gives a single individual, an unfairly large, chance to influence something where there's really no legal reasoning that they would be involved.
Yeah, and I agree with that. But it's also, to me, it's the appearance that somebody that is decidedly for or against something has a special rule, which is they aren't limited by the 10 minutes. Because I think if you're not if the councilman is not on your side and you see that happen, you think, well, okay, they're getting more time than we are. So I'll take a stab at a motion. If it gets a second, it does, and we can discuss it more, but so that we kind of understand. I think what I would move is that council people who are coming to speak and they're in a neutral position can speak either at the beginning of the meeting or when the case is called. They're not time limited. Council people who are coming to advocate for or against an application should be required to speak while that application is being considered, and they should be they should have to speak within the 10-minute parameter that is given to either the applicant or the opposition.
Yeah, I second that.
Okay, there's a second, so we can discuss now. I wanted to lay it out there so we kind of.
I get the intent. I think it's hard because who's going to determine whether they're neutral or not? Is that the self-determination of the?
I'm willing to take them at their word on that. I mean, I don't think we want to weigh into. I mean, I'm willing to take them on their word. If they say, I'm here, and we've had plenty of them say, I'm not for or against this, but I do want the board to know certain things. And I'm willing to take them at their word. I just am. Because I think it becomes a can of worms, Robert. I think that's the point you're trying to make, is if we also have to decide, well, are they for or against? And I trust them to be forthright with us. And
Well, and I mean,
It helps draw the line a little bit more, is what you're saying, where they stand, if they.
I mean, most of the time, when a council person is in support of something or in opposition to something,
They stay
as
there,
we've seen them sit at the table with
Yep.
the applicant
Right.
and then take up a lot more time
Right.
than what the opposition said. And like the whole point of us going through these rules, and to Mr. Bradford's point, we are quasi judicial. We're not like any other commission, so the whole point is to maintain fairness. And so we don't want to tip one side or the other in time and getting to explain their position just because they lucked out and got the council person on their side. Because that's not the point. We're not supposed to be swayed by that. So I agree with your motion. I think it's worded perfectly. I will vote in support of it.
okay.
May I add something just a little bit?
Sure.
This is just something I've observed both as your staff, but also in private practice. I've seen it occur, and maybe infrequently, but the part I just want to caution you on is letting that council member talk after the opposition, like the applicant put on, the opposition came, put on, he rebutted their testimony, and then the council member comes in and applicant doesn't get a chance to rebut the council member's testimony. So let's make sure the council member's lumped with the opposition time.
That
So-
was, I thought
Yeah.
I worded
And that's,
that
it's
way.
inherent,
Yeah.
They
it's
would have
inherent
to
in what
speak
you're doing.
within
Yeah.
the parameters given to the applicant,
There you go.
which would include the order in which they speak.
I got you.
They wouldn't get to carve out 3 minutes and say, okay, I'm going to
Well,
make mine at the end.
frankly, I think that, in terms of determining the order, if the council member wants to speak during the case, ask them, are you in support, opposition, or are you neutral on this?
Yeah.
And then that, you can sequence this presentations,
Happy to do that.
and I think, if they're nervous about saying one way or the other, then
Yeah, no,
that's,
I don't mind having,
Yeah.
just asking them.
Yeah.
Because now, it's harder for me sometimes when a new council, because I don't know them. I haven't learned their faces, I don't know who they are, but now we've been here long enough. I can see them in the audience,
Yeah.
like, hey, which side, I can find that out.
Ms. Davis makes a great
Sorta.
point. I mean, sometimes they're wearing the same matching color T-shirt as the opposition is or something,
Right,
it's.
that one's That's
So-
what give me.
If I may say just one thing, I understand where you're coming from, but to me, it says courtesy. So I'm hoping, we as a quasi-judicial body, we are not swayed by what council member says. We are based on, deciding based on the fact and based on the regulation. So to me, it's just a courtesy. That's why I thought being lenient, because they are elected official and representing. So that's why it's appropriate. And also, the council members should not take advantage and, speak 10 minutes, 20 minutes, and then advocating for one side or the other. So that would be the kind of mutual understanding. But I do understand where you are coming from as well.
Yeah, and I understand, council members sometimes get caught in a position because, they have to make their decisions based upon the people that vote for them and elect them. And so sometimes I think their position can, for better or worse, come down to a popularity contest within their district, or who's got the biggest and loudest and most organized voices. But that's not always, that doesn't always mean that big, loud, organized opposition or voice has a valid argument under the sort of provisions of the code, so.
I mean, listen, I've been here, the shortest of mine is Mina, or Ms. Johnson, but has this stemmed from a issue? I've never felt like any of the council members that have come here have used up time or.
Yeah.
It's been over my head.
I've seen council members basically add double the length of time for opposition or support of something. And frankly, I mean,
It doesn't happen all the time, that's for sure.
Maybe I've just thought that was the norm because I'm still kind of new to it or something, maybe.
It doesn't happen that often.
Yeah.
And I think the courtesy part, I agree with the courtesy part, because a lot of the council members, this is not their full-time job. They have full-time jobs. They need to go to their full-time jobs. So to be able to speak at the beginning is a courtesy.
Well, that,
So
my
I'm
motion
on the
includes
line
that.
of
It
Yeah.
allows them to speak at the beginning.
Just not in support or opposition.
Yeah, if they're.
I mean, the people that are here also have, a lot of them have full-time jobs, and the applicants have full-time jobs, and so, I mean, I think that's one of those,
It's a
my
little
view, you know.
different, I think,
What-
to me, and I would like, as a BZA member, to have courtesy too. People to be courteous to us as, we are volunteers, we don't get paid for this, so, I don't know, I'm on the fence.
Is it odd to say that as a courtesy, they could, speak at the beginning, but if they're for or against, whatever time they use gets taken out or something, or is that out of kind of context a little bit?
I think that creates a problem for, if the opposition is getting a chunk shaved out at the beginning, then you have the applicant present and the opposition suddenly has, a shorter period of time. I think it just creates process issues.
You could do that, or as chair, as the board, y'all figure, let them speak early, and they're against it, but they got to go to their meeting. Whatever time they take, just portion that time to the appellant to
Okay,
have.
so I'll amend my motion and say that if they want to speak at the beginning of the meeting for or against, that's fine, but whatever time they take comes out of either the applicant. If they're speaking for the applicant, it comes out of the applicant's time. If they're speaking for the opposition, it comes out of the opposition's time. I think that allows them then to speak if they want to be neutral at the beginning, or if they want to.
Again, I guess they have to answer, if they end up, talking for 6 minutes, they're taking it out of whoever's time that's, also here. And so that
Right.
they're going to have to answer to the people whose time they're eating up. So good luck to them.
Or if they're neutral, they say they're neutral, so no time's being taken out, but then they talk about 6 minutes about how maybe necessarily,
Well,
intentional or not.
I think we
right?
can cut them off if that's the case.
To be
I mean,
fair too, y'all have allotted more time. When there's clearly more
Yeah.
to be said, you guys have been, hey, can we let's give them both sides another 2 minutes.
We've done that a lot.
Yeah,
We've
so
allotted more time. I think.
But I mean, I don't think anything's preventing us from, if it appears that there's statements that are not comporting with the rules, from us stopping that presentation. Not that anybody wants to, cut off a council member, but I don't know.
If I may throw the curveball, because when we are asking question, either support or opposition, clock stops. So as far as time distribution is concerned, it may appear one side is speaking more because we do ask so much question. So if we are, concerning about the time distribution of fairness, so limiting or including council members' comment to either or may kind of, unfairly, seems unfairly in a way. So I think just to leave it as is, unless council member, I'm sorry, I understand some of the board members, fellow members were subject of taking advantage of, taking up so much time, but assuming council member will follow common courtesy, because it is extended to the courtesy, and then follow our intent will be my hope. So I'm not really big on changing the rule to adding, or deducting the time either way. So I rather leave it as is, as a courtesy might be cleaner approach. That's how I feel about it.
Okay, so any further, I'll restate the motion, just so the motion would be that if a councilman is not speaking for or against, they can speak at the beginning of the meeting and there's no time constraints, or they can speak when the case is called and there are no time constraints. If they are for or against, they can speak at the beginning of the meeting, or they can speak when the case is being called, but their time, whatever time they use, will be assessed against whoever they're speaking for, so that they're subject to the same restraint as the applicant or the respondent. And that's different from my previous motion. So
Yeah, I guess I don't have an issue with it. I mean, honestly, if they spoke for 4 minutes and all of a sudden it shortened the opponent's ability to speak, I mean, I guess theoretically we could add 4 minutes onto the applicant and then give the opposition a full 10 minutes so that it's weighted, but that just adds time to the meetings. But I mean, and then for the sake of consensus and to not, totally blow up the concept. I think, generally speaking, my main thing is the fairness question and making sure that the scales aren't being tilted, and so I think that does it. So, I'll second that as is, so.
Can you second that? That's a little.
Yeah, I'll second that, yeah.
All right, so there's a motion and a second. Any further discussion on it? All right, all in favor? All opposed, so that passes 5-2.
One abstention.
Well, 5-1,
Yeah,
with one
just one
abstention, okay.
Restate that again, just so I make sure I have it.
Sure, so if a councilman is here to speak on an application and they are not for or against, they're neutral, they can speak at the beginning of the meeting, they can speak when the application is being considered, and their time is not limited. If they are here to speak for or against an application, they can speak at the beginning of the meeting or while the application is being considered, but the time that they take to speak will be assessed against the party for whom they're speaking, and they're subject to the same restraints, meaning they have to speak during the time allotted for. If they're here to speak against something, then they don't essentially get the final rebuttal. They've got to speak within the time allotted for the second position, which is allotted for the opposition. So they're subject to all the same restraints as anybody speaking for an applicant or a opposition would be subject to.
We can exhume William Faulkner to write that rule for you if you'd like us to.
Yeah, we'll draft it and bring it back to you and let you look at it.
Yeah.
The next one I'd like to talk about, deferred cases. We've kind of internally shifted this around. If you've noticed on agendas, we've got old business and new business. The way it used to work is deferred cases. If this board deferred a case, they always kind of put them at the front of the next agenda. And then if the applicant chose to defer for whatever reason, that case would slide back behind what was already assigned for today. Not really, not a penalty per se, but if you're making the choice applicant to defer, then you slip down the agenda. But if the board calls you to defer, we pulled you up toward the front. What we've kind of done now is had an old business and a new business and just sorted them by case number. Do you have a preference one way there? We're happy to rewrite this section. What do you like better?
The old business has been really confusing.
Okay.
Because I think there's been times when people are not aware they need to, or they could watch a video and
Gotcha,
vote on a case.
gotcha.
And so I've been really confused by the old business versus the new business.
Because sometimes it's old business, but it's
never been heard.
It's not been a public hearing, but
Yeah.
sometimes it's old business and there's
Gotcha.
been a public
Yeah.
hearing that's been continued and stayed open for additional.
Yeah, so to me, old
evidence.
business should only be the cases we've heard and need a decision on. Or, I think new business should be anything we've never heard.
Gotcha, okay.
Well, there are some times where we're in the middle of a case and then it gets deferred for whatever reason.
Yeah, we just tinkered ourselves sort of.
You're talking about the ones that get
I'm
deferred?
not saying outside the rules, but we're trying to find a way of formatting it where, or if we had a case where, hey, February got canceled because of snow, so all those cases sort of shift. We just kept them and, they're first. These guys that were normally scheduled get pushed. But you're right to the extent y'all postponed it or they chose to postpone it. We were putting it on in old cases. This rule that's in here is prior boards were in effect saying, you've spent our time as a board talking about your case, and now you want to defer, you're at the back, versus the board's like, hey, we need more information, and obviously they're going to need to defer. And y'all have seen those cases where you're like, let's hear them first on the agenda or toward the front. Mr. Ransom's probably not saying it, Ms. Johnson, but other board members who've been here a little longer is like, you guys chose to put them first. Well, sometimes we ran into a situation where you said, a couple of cases are all first, they can't be first. But so we're happy to go back to the way, that's sort of intended. If the applicant's chosen the deferral, they just get pushed back behind the stuff that would have regularly been heard in its filed order versus if you guys chose to, hey, we need some more, we need that survey, you're deferred. We'll hear you first 2 weeks from now.
I feel like the easiest would be if we had it as like cases where the public meeting is closed or the public hearing is closed and the board it's tied up or hasn't gotten 4 votes or, it was 3-1 or something like that. I think that, do that. Then cases where the public hearing has been opened, but the case was deferred. Frankly, I don't really care if it was because of the applicant or because of us. Sometimes it feels like it's in a murky situation. And then, cases that are on the docket for the first time are after that. But that's just kind of how my linear brain works. So,
Yeah, I don't feel like, whether we hear a case immediately or hear it a few cases later, it's not like it's weeks later, right? It's still heard the same day. So I would say I have a little preference, whatever is easier. Going back to the confusion though, I think when Elizabeth was here, she was always, in her emails she would send out, it was, and this is not a critique of you or anybody, but.
I'll tell you right now, she was excellent. She's far more organized than I am.
Yeah, so she would say, this case was heard here, it's minute 32, right? So Ross and I had an issue.
Right, I missed it.
Where the deferred cases, we thought they were just deferred, we're going to defer this case. Not that they were heard and then pushed.
Yeah.
So we didn't know we needed, or sounded
Valid,
like
that's
we
a
didn't know.
valid point.
That's
And it puts y'all in
Yeah.
a light, and I'm sorry for that. Let me do that publicly since we're being recorded. It puts y'all in a light, y'all messed up. And I didn't tell you that you couldn't participate because you didn't know. And Mr. Cole too, y'all didn't know you could have watched the tape
Right.
to be eligible. So that's the other part too. And I made a note here to myself of any absences that you're not present at this meeting and we didn't get a final conclusion, it's tied on votes. I'm going to send you automatically a link to that case, timestamp, hey, here's, case 3 on the agenda. If you want to watch it, you're eligible. Otherwise, you're not. We'll just do that automatically and I'll do better on the agenda side of organizing it like Ms. Waits did. Because,
This may be a semantics question for lawyers, but would it be crazy if you relabeled a deferred case as truly a case? How would we know without, I guess, maybe you can just tell us, but one that's been not heard and deferred versus one that's been heard and deferred?
I have a thought on that, actually. I don't have a docket in front of me, but isn't there a place on the docket where it says results on the bottom?
Yes.
Is it possible to write, this is the result from the last meeting, it was tied on votes 2-2?
Yeah, we'll capture.
Something like that.
Even
yeah.
better, what I thought, and Ann and I have talked about it too, is in the caption, the labeling of the case, we'll put previously heard by the board on such and such date, deferred on to this date because of whatever. Need more information or whatever it was.
yeah, and I think knowing whether the public hearing is
Public
open
hearing remains open.
remains
Public
open or
hearing's
not. So in terms of taking in,
And
We'll
that's
make-
not just for us, that'd be for the public.
For everybody
They would
too,
be able
yeah.
to
I'll make
see
those
that.
changes immediately.
because in that case, that way we know if we're going to give an applicant, and maybe we should even put this in here if we have a continued public hearing, you get 3 minutes or something, or 4, I don't know, I felt like we jumped between 3 and 4 last time, but that it's, we set some super tight time frames for those.
In this rule, you can always amend it by motion anytime you want, so that's fine. That point's taken. I'll make sure the next April 3rd that's published will look different. I'm gonna fix those so it's a lot more clear. And for the members who didn't attend or may need to become eligible to vote, it's your choice to become eligible or not. I'll send you the link to those cases where you can still participate. I'll do that. That don't necessarily need to be in the rules. That's more we'll do that.
So just for under D and deferred cases, where did you land on what you'd like to see here in the order of the agenda? Is there any consensus yet, on how you want it to be
Sounds like we
structured?
landed in about 4 different places.
Yeah,
but,
I just wanted to bring us back to that point, so.
I think maybe it would be helpful if, I feel like maybe we sort of, everybody's kind of in agreement on the way it should look. It's just more of the observation. So I don't know if, not to shift it back to y'all, but if y'all could take a crack at essentially, I think we did agree that it doesn't matter. We didn't really care if it was at how it was deferred. Oh, okay.
I think maybe, please everybody, maybe you put it within the board's discretion, make it a May may, let the board decide, because there have been instances where Joey's talking about, and I remember when I was early on the board, where they did that because they didn't want applicants abusing the process. Like, they would show up, and then if they saw there was a lot of opposition, they would be like, oh, well, we're going to defer it. But they only did it because there was a lot of opposition. It was sort of disrespectful to the opposition to do that. So that's why Joey or whoever would put them at the end of the docket. That doesn't mean that it should happen all the time. Maybe maybe it shouldn't be a shall, it should just be more
Or
discretionary.
they got here and there was only 4 members, and like, oh, God, I gotta have all 4 votes, and.
Exactly. Like, people are trying to.
The only
gain
thing about the putting those, because I agree with you, but my reasoning on not having them at the end of the docket for that is if the opposition comes back and all of a sudden the opposition has to wait for.
Well, sometimes we've said, like, when there's opposition, like, oh, we'll hear this at the first. Like, I don't think this rule has been that problematic, but if it would make everybody happier, I think if you just change it from shall to may, or make it more discretionary, then it puts it on us to decide where it goes on the docket.
Or you could say that those cases that have, the public hearing's been open, y'all have heard testimony, those come up front, and those that hadn't had any testimony, they'll just go to the back. You know, 'cause
Yeah,
we hadn't opened
that's a
the door-
good-
We hadn't
that's a
opened the
good-
door yet, so.
Well, and
that way-
those that haven't had, and where I like that, because if the public hearing hadn't been open, it's basically the same as a new case.
Yeah.
And so you just go to the bottom of the list so you don't inconvenience the people who were.
But if there wasn't a public hearing, then that wouldn't happen, because this says prior to a public hearing. So if they just showed up and then said, that's what I'm saying. I
Yeah.
think, like I said, I want consensus, but I think the way that you solve for this is just don't delete shall and make it somehow discretionary. And then it's up to us to decide where it goes on the docket, based off of what we observe in the room. It shouldn't be automatically to the end, because like you said, some people don't care, and it shouldn't sometimes automatically be the front. Sometimes we might want to push something up.
Well, and I also know that there's times when I feel like we should take cases out of order. I mean, we don't, I don't think we do it very much, but, you know, if you have a huge number of folks here on a case that, you know, I think our rules give us the discretion to vote to take a case out of order. And so, you know, if there's a lot of people here, maybe we should exercise that discretion more to take them out of order. I think I could get on board with your sort of may.
Changing both shalls in this paragraph to mays.
Yeah, or just,
Okay.
yeah.
All these rules have some history behind them as to why, that predate me. Some of these are carryovers from long, long ago. One of those we'll talk about in a minute. Consent agenda, are y'all happy with how the consent agenda is working, flowing?
How
Good.
the consent.
Consent agenda, are you happy with how it goes?
Oh, sorry, Brett, before we jump to that, I know B was one C, the board shall be considered, the code shall be considered part of the record in every case. I don't know if we need to expressly put this in there, but that state basically the Tennessee code and then Metro's sort of parcel records we'll pull up Parcel Viewer, we'll pull up permitting files, which I think can be helpful if there's a question that comes up of, you know, I think if we're trying to suss out someone's testimony, if they're being upfront and honest or not, if we can pull records to indicate one thing or another.
Now, those will be part of the record. The genesis of this was, we didn't have this in our rule, and I don't know, somebody brought up, you've got to read that into the record, you know, Mr. Codes official, and that's what we did. It was like, hey, all our codes are part of the record, regardless, because, you know, we talk about it in the ordinance, you know, you have jurisdiction under this. I don't have to go read the jurisdiction section out loud. But now, to your point, what we're talking about, like, hey, Joey, can you show me parts of that's because it's being recorded. That's already in the record. We're good. So we're there now.
Okay.
For court filings, courts that don't necessarily, you know, they want a paper copy of what I showed, I'll have to go in and print that map out contemporaneously. But I'm hoping courts will eventually just kind of watch the YouTube like everybody else does and goes, oh, yeah, that's what he said. Maybe I'm dreaming on that. Let's see.
Does that resolve your question there?
Yep.
Okay.
Let's see. Kind of F there. The only things you guys should be considering are the testimony brought to this board. It's kind of apparent, that's an F here, that you should be basing your decision on the information submitted to this board, the testimony by the opposition and neighbor and the appellant, and it's not something else. And this is where the discussion is, well, Peyton and Joseph went to the site and we looked at it. It's fine that you go look at these sites, sure, feel free, but you just need to disclose on the record, like, hey, I drove out by this site. If you did drive out by site, I would always disclose it, either right before testimony, hey, just FYI for everyone, before I'm, maybe right after I'm done with my presentation. Hey, Joey, for the record, I'd just like to disclose I work right next door to this, or whatever. I drove by it, but don't two of y'all go together, But that's what it's saying here. It's just reaffirming that we're following the Open Meetings Act. We're not considering stuff outside testimony. There's the Open Meetings Act, section 844, down at the bottom of that page. This is more the guts of, here's kind of the format of, how we're going to hear the case. I'm going to present here's all the stuff they turned in, and here's what they're asking for. And then the applicant goes first, and those people, your time limits are built into this section. They were scattered about in other parts of the rules, so we just consolidated those here. Were there any changes to any of these?
I just highlighted them in sort of the context of the council member stuff that we had discussed earlier, just because I think there's some of this gets implicated by that.
When I first started as staff for the board, we didn't have time limit. Talk as long as you want to. Go for it.
For any case?
Any case. You could talk as long as you wanted to until and I joke, like, there ought to be a time limit on the board members talking. It wasn't so much the applicants, it was the back and forth from those. It was just the personalities of that board at the time. We weren't televised. We had an audio tape that we recorded. Then as membership evolved and we'd get different, from my point of view, we have different personalities. So you get, a different flavor of this board, if you will, and it evolves over time. So it's kind of fun for me to see how that changes over time. But and then it was like, man, these meetings are just going on way too long. And so the board's like, all right, let's do 15 minutes aside. And I think somewhere along the lines, you're down to where you are now, 5 unopposed, 10 opposed. Just tell you from my standpoint, y'all pick whatever you want. It's fine with me. I've seen it all. I mean, folks with that. How long does the board meeting last? We start at 1. And that was the reason the board stayed at 1 o'clock when there was a push in the early 2000s to move to evening meetings, because our meetings were long. So the board at that time, told the mayor, we're not changing from 1 o'clock because our meetings are 4 and 5 hours now. We wouldn't get home till after midnight. So, your time frames, if you want to change those, great. I don't think Ann, you or I, either one really have a position on it. We'll enforce whatever you want to do. Or if there's something, hey, this doesn't work well. I think you've solved one of the concerns for me is I always felt just a little uneasy when that council member got to talk a little more one way or the other. It just never felt, and I think, Ross, y'all have done a good job of giving this guy a little more chance to speak or giving him sort of a second rebuttal to, where the council member just brought up something totally out of the blue. It just wasn't fair to an applicant to not have a chance to rebut that. But were there any items in this along this page, anything that you guys wanted to, good with the time limits as they are? I think we do a good job of adhering to them.
I feel right.
Let's see, same, this is item A, appeals. We reworked this section to flow like we've been doing it recently, where the appellant goes first. I mean, it used to be the zoning administrator went first and explained, here's why I did what I did, and then the applicant came and said, well, you did it wrong, or whatever, and then that was it. So what we kind of do now is, I think we've got written in here that the applicant, whoever's appealing the zoning administrator's interpretation, goes first now. So they're the appellant. I'm sort of the opposition, if you will. And then there's a third party of other interested parties. Let's give them 5 or 10 minutes to talk. But and I'm, as long as I'm zoning administrator, I'm not taking 10 minutes of your time. My goal is to write a letter to try to explain with some specificity in that letter why I did what I did and save, the nuanced stuff to where I'm sitting in front of you to tell you, here's why I called it rec center. Those, like that case, we're past 60 days, so I can talk about that one. And I think this is important for y'all, not necessarily in this, but in general. With recent changes to the Tennessee Code, the legislature is very serious that an applicant's application runs by the rules at the time they apply for the building permit. So you had that rec center where the council member went and amended the section of the code of rec center to take that batting facility out of it, and came to me and said, well, y'all can't hear this case because I changed the definitions. No, sir. This case was filed before you ever filed your legislation. It tracks. So his change was, in a sense, to try to stop that item in front of you, and he couldn't, because the law at the time the application was filed there's now a statute filed in both the House and Senate versions of that. I'm not going to bore you with the other details of it, but it's pretty in-depth. The legislature's serious that we're going to protect the applicant, whether it's a contractor, a homeowner, business entity. The rules are when you file for it. Legislature, you can go, local legislative body can go change the law all you want to, but if you get filed, you're in. And that wasn't always the case. So there may be times at which I present a testimony to you like, well, the rule is this, but just through the grapevine, well, didn't the rule change? You may see instances where that the next case is filed is going to be something totally different set of rules.
But I think that if the change is in a manner that opens up the options, then if somebody filed for something and all of a sudden statute changes to where they no longer have to come get a variance. Like if somebody filed a case to build a porch that encroached 4 feet into the setback, and then the bill passed that allowed 6 feet as of right, we're not going to make them come argue for that.
We'll withdraw it. If it's permissive or gives them more rights to their property, I'm going to withdraw. If it runs to home or cut against the rights of the property owner, we're going to stand by the rules at the time we follow. I'm glad the legislature finally got that straightened out. It took the courts a minute to get on the same thing. Section K, just other public hearing type things. They can ask more time of you if they need more time. They can. This rule's changed over time. It used to be, applicant or opposition, you got to ask for that before the board meeting even starts. And I trust you guys to know, whoever's chair, vice chair, hey, they're going to need a little more time than 10 minutes to get this out, because this case is a little bit complex. Feel free to tack that time on accordingly, give the other side the equal amount, and everything's fine. It talks about that here. All the exhibits that, this is one we have to talk about applicants, because there's a lady in prior cases that may have turned in her only set of pictures that she showed y'all. That's part of I got to keep them for 60 days after this hearing. So what we'll do is photocopy them. Hey, come by Monday, pick them up. That's why I don't, hey, I got something on my phone here. I should take your phone. But send it, email it in to us. We've got it. The connections in here are great. Years ago, I couldn't show you an email. We didn't have any signal in this room. Let's see. You're allowed to reopen the public hearing anytime. So that's sort of that section. Was there anything you guys had I didn't?
The only question I had is, it says upon conclusion of all testimony and evidence, the public hearing will be closed and no further evidence may be admitted, but I just want to clarify that we can still ask you questions during that time.
Yes.
Maybe that's worth putting something in there. I just want to make sure that if there's a question about that you can help us with, that we are.
Yeah, we've considered that questions to staff, me or future staff, that's all part of the public hearing portion. My job is I'm not testifying in the case. I'm just answering your question. I'm not giving an opinion on their thing. So just I guess I'm going to ask from the chair, who, hold me accountable to that, because if you feel I'm providing an answer that kind of like, well, the guy needs to rebut Joey's answer, just feel free. But yeah, I'm kind of like, I think the court would agree that my answers to your questions, if it helps you formulate the decision, is clearly part of the record. And I know in times past, we've included everything in that time window to do that.
So we should close the public hearing after we've asked you the questions that we need to ask.
Yeah, I would say to make it cleaner, just don't close the public hearing until you're all ready to start making a motion and deliberation. That way you leave time to ask Ann a question or ask me a question. Technically you probably should open public hearing, but I think.
So can we keep it, so when the testimony is concluded, we can keep the public hearing open while we deliberate?
Well, I think that's for you guys to decide. I think you need to find the line between, we've got enough information. I think we can close the public hearing then. If you've got enough information, shut it down.
We've opened it back up.
You can always open it back up anytime you want to.
Yeah.
I'm afraid if we left it open to deliberate, people
that's true.
would chime in.
Right.
Yeah, I think
no.
you need to close it. I think
You should.
it would make things very.
It does make things much cleaner.
Leave it open sometimes, see what happens.
I tell you what I do, I have to go back and watch these. I watch these prior meetings to make sure, did they close the public hearing? To make sure, the public hearing's closed. And I've had that, I'll tell you where I've had that with council members that come, they couldn't attend where the actual public hearing happened, but they show up at the next meeting and want to tell y'all something about that case that's it's deferred, but the public hearing's closed. Like, no, it's closed to you too, sir. I mean, it's not, it's closed to everybody unless they want to reopen it. Let's see. So that portion's wrapping up here. So, of course, talks about you guys have to do 4 affirmative votes. Ms. Johnson, you had a question here. Are board members allowed to ask questions before casting their vote? I think in general, yeah, but if it's one of those where your question leads to, as a board member, you need a little bit more information to make your decision, I would make sure you just open a public hearing to get me on the record. Or a witness, maybe, I meant to ask the civil engineer this question. In your rules, you can ask a question of anybody at any time. You just need to open the public hearing to get that answer, before. But I think once you're...
So,
About
I mean,
Robert's
I'm going
rules,
to
where
differ
you
with
at?
you a little bit here, Joey. My concern is that everyone should be voting based on the same information. So if certain people have voted already based on a certain amount of information, and then someone comes in later and elicits additional information,
okay. I
and they're
misread
basing
this
their
section.
decision
Sorry.
based on additional information, I think that's a problem.
Yeah,
My thought on this is that I think it's fine if you're just like clarifying some facts, like just some confusion about the facts that are kind of in the record already. That's probably fine, but like in a very limited way, but like in no way should there be like additional evidence being brought in or additional deliberation taking place. That's where I would draw the line. If it's just like a very simple, like, can you just remind me, was it like 100 feet or 10 feet or something like that? Like,
Yeah, but the problem is that
but-
when you ask anybody, was it 100 feet or 200 feet, they say, it was 100 feet, and also let me tell you something else I forgot last time. And
I was thinking that,
I think
no
this question is
public should
more-
be speaking. This would be more directed to
This
Joey.
is
like a
where
staff
you
question,
missed
but-
the agenda, and now you're watching the tape. And now you have a question, and I misunderstood that when I first.
Yeah, so that exactly.
That's problematic.
Right.
I agree with Ann.
What I
That
was
should not happen.
thinking about, after watching, say I was not, a meeting, and then you had great deliberation, but if I were there, maybe I wanted to ask that person or engineer, I wanted to ask that question. Without that, I won't be able to make a right decision, or if those the case, is there any remedy for that? That was a hypothetical question on my part.
There's not a remedy to that. What I advise you is, if after watching testimony, if you don't feel you have enough information to vote, then don't participate. That's what I'd say.
Yeah, I agree with that. If you can't make a decision based upon
That's
what's
okay.
already in the record.
And I'll poll you.
Yeah.
And did you watch the information? Yes, I did. Do you wish to participate? No, I do not. And that's all you have to say. I won't quiz you as to why don't you want to participate. I'm not going to do that to you. But I mean, I will ask, have you watched the information? Answer truthfully. Yeah, I sure did. But I don't feel comfortable participate in this case, that's fine. I'll just mark you as absent and, no harm done.
I feel like I came to one case I watched online. I feel like we opened it back up for a question in the past. That's been done, I think. No?
I don't recollect that, but we might have,
Yeah, we may have.
I don't recall doing that.
I have a question about B. I think you're on B right now.
Yeah.
So it says, if motion fails to obtain 4 votes, the case shall be deferred to the next board meeting. And so what happens if nothing happens at the next board meeting? Didn't we have something like 2 meetings?
1740, 240 in that section that's referenced covers the specifics. So they have to have 4 affirmative votes within 30 days of the public hearing or it's deemed denied by operation of law.
Okay.
When I say those words, it's because that code section says
So-
that.
So it's 30 days. We can't change it to be 2 meetings? Because
No.
some people
Unless the
luck
code-
out and get 2 meetings in 30
Yeah.
days and some applicants don't.
It just, that's the way the ordinance is
Okay.
written. This is a
Okay.
section that we can't, the council can change it. And
Okay, so
but
the council, I mean, well, yeah, would that be a proper thing for a member of the board to write the council about changing, since it's one of our procedural things? I don't know that that would fall within our wheelhouse, but I do feel like sometimes people end up, especially if it's like in the summertime and we're jumping from 4 people and then all of a sudden it might be 4 people, but it's different people based on vacations and stuff, that people kind of get the short end of the stick.
So
And
if they
it's-
change it to like 45 days or
Or just,
60 days? or
yeah,
what are your-
I don't know, or 2, it stays on for 2 meetings following so that, at least there's some, maybe 3, I don't know if it's 2 meetings or 3 meetings, we can figure it out, but I mean, if everybody's here at some point, it's likely to get 4 votes one way or the other, but I think the problem is like, if there's, as Ms. Carpenter pointed out earlier, everybody here's volunteer and has travel in the summer for vacations, has holidays, has work stuff. So just not to be unfair to applicants for, because there was a case, and I think that, I think the 60 days is run on it. There was one involving the church up on Ashland City Highway where we had, but there were 4 people here and then there were 4 people here. And I think it failed because it never got to 4, but at different points there were 4 people who.
It feels like every case should be able to have the ability to have 4 votes, either affirmative or opposed, but it feels bad when a case gets
It just dies.
thrown-
And it's
it
just
dies
because-
it's tied on 2-2
Or 3-1, and it's
just
like
seems
that for
everyone
2
should be
meetings in a
afforded
row or
that
something.
opportunity.
Yeah,
To have a
council's
case
going to
really
have to change the
decided.
ordinance to change that. I don't, if you're obviously a resident of Davidson County, I think you could ask.
Yeah, I agree with you.
Yeah.
Yeah, I think you could,
It's kind of luck.
Yeah, it's luck.
It's luck. It's luck.
yeah, I think you could certainly,
That's something you want to bring to council, like,
Okay.
yeah,
I don't think there's any harm in
maybe
that.
clarify, you think 2 meetings, 3 meetings?
Yeah.
That's
Yeah,
something-
because then it's like, well, maybe it is different folks at the next meeting, but if it was a long meeting
Yeah.
and the person hadn't had the chance to watch the video yet, then it's all of that is out of the control of the party that's seeking relief one way or the other.
There was a board in Alexandria, Virginia, where if you basically didn't die, it automatically got approved if you couldn't get a quorum after a couple times. Because one of my projects was
Bet you there's some statutory language at the state level that says that. Not to say that may not be coming Tennessee's way. There are many jurisdictions that say, hey, local jurisdiction, you've got X amount of time to thumbs up or thumbs down, but if you sit on it, it's approved.
Yeah.
And I bet you there's some underlying current in the Commonwealth of Virginia that has that.
I was a lucky applicant on one that got approved that way. The
Tennessee's
neighbors
trending
were real
that
happy.
direction. Yeah, they're trending that direction.
And it wasn't a good thing. They asked me to come back because they weren't allowed a public opportunity. Anyway, I didn't think it was a good thing, but.
Well, there's definitely, that's trending here because the legislature has set some timeframes on building code reviews, and you've got X number of days to get these plans reviewed, otherwise they're deemed approved. So it's already begun. Kind of what's up here, kind of the next 2 sections, just, hey, if you're going to grant a variance, you need to, don't just say I move to approve, second, all in favor, aye. I move to approve because the hardship of, hey, y'all do a good job. Boards past didn't do such a great job. So I've seen it both ways, but this board in particular does a very good job of stating what the hardship is. I will do my best if I hear you headed down the road, Ann or I'll be like, what hardship are you basing this on? I'm going to stop you before you get to voting. Same with a special exception. Hey, I find that the applicant meets all the conditions of whatever. I mean, great, you're covered. We're just sort.
Yeah, mainly that, it says the board shall indicate the hardship warranting the granting of the variance. I think there's something in the code that the code itself says, make an affirmative finding on the 7 factors. But, my understanding is we have the ability to sort of weigh those factors, and we can do something like, I think most of the time it's, if you have a lot that's, shaped like a parallelogram or something like that, it's clear that's it's an overriding unique shape of the lot is the basis for it. How do we need to structure it so that the other factors, we can check the box, but not, acknowledge that they don't really apply or they're not as, the weight isn't as important.
Are you thinking about a variance or a special exception? Because your comment is next to the special exception. It sounds like it's a variance question, right?
The highlight was for the both, but yeah, it's really a variance. It's really a variance question, right?
Okay.
I probably just didn't highlight very nimbly.
The courts in Tennessee, the statute is copied straight from the state law, but the case law in Tennessee has found that boards of zoning appeals, so long as you find a factor, you're good. You don't have to check all 7.
Okay.
As long as you're shaped. Now, the more you put together, the better you are, but you're not sitting here going through line by line. It doesn't impact the, master development plan. They've just not found that you have to do all that. They're upholding you so long as you're finding a hardship in the law.
I think it's more implied that there are findings on the other factors. I don't think I've seen any case law explicitly saying you don't have to address those other factors. I think
it is
do.
implied.
I think this is the reason, and the other factors really don't impact our decision one way or the other.
Yeah, I think that the other factors are factors you need to take into consideration. Just some are more, worthy of discussion in the context of specific cases than others. So.
And I've kind of advised applicants when they get that hardship form from us that lists the hardships straight in. They really honestly are kind of written in order of, and I've said it, more important to least important. There's something physical is going on here that's stopping you from complying with the code. And then we're down to, hey, my situation's unique compared to the other guys. And the next one's like, well, it's not really harming the adjoining property owners. So as you read it, even in the state statute, it's sort of, tiered a little bit, that physical hardships are clearly more of a hardship. They're all equal in the eyes of the law, but there's some that seem to carry more weight than others.
Well, there's just more case law on that.
Yeah, there's more case law on it where it's not, well, the board granted it because there's no harm to the general public of Nashville. That's not a very good hardship to base a variance on. So you need to sort of find something in particular. But and then special exceptions, same way. Case law, special exceptions, Tennessee, if they've checked the boxes on the specific conditions, you're supposed to approve it.
And the general provisions as well.
And general provisions as well. There's no reason for you to not approve it. The court's even told this board, not y'all, but this board in prior case law, you shall. The court's even issued a special exception over this board and told you. That's very uncommon. The Mumbrium case, the court did it. The court granted them the approval and put the conditions on there. They felt that this board just acted.
That was the one where they said, well, the guy was being a bad neighbor, so we're not going to give him his relief.
We disagreed, but the court felt that the board was just way out of line, that they just gave him the permit. It was such an unusual situation. Y'all are doing a great job. You're not going to find yourself in. These last ones, just, hey, if you don't show up, you're toast. You
Sounds fair.
Yeah, you don't come, you've done everything, but you just didn't show up. Now, unless you got a good reason. I find out later, well, I was in the hospital, Mr. Hargis, mom passed away. Something, give me something, I'll put you back on the agenda if it's fair. But if you just didn't show, you're just
One thing that I was curious about, because we did it, I think I made the motion at the last meeting about this, but it was the dismissal where we have no jurisdiction. So if we have a case where the board lacks jurisdiction and can't hear it, how is that? It's not really in the rules per se, because it doesn't say, that we
Was it that fence one?
we should move to dismiss a case.
Our
Yeah.
order, the order entered in it, we wrote the order as denied due to the board lacking subject matter
Okay.
jurisdiction.
Okay.
How we wrote it, to give that fellow the opportunity to appeal to Chancery
Okay.
if he wanted to.
Yeah, that would need to be in your rules.
Okay.
I feel like we've, going back to the fund fence option, I feel like some fence options or cases that have come in front of us, I feel like some of them have been in the right of way or other areas. Because correct me if I'm wrong, but that particular one it was in the right of way, so we couldn't
Yeah,
rule on it?
yeah, y'all can't grant variances in the public right of way.
Right,
There's a process for him to get that, it's through the council.
okay.
My argument
remembering
was,
that.
I'll just withdraw you, go to the council and get just like all the honky tonk signs hanging over side, that's an encroachment. You can go get an encroachment for your fence. He was adamant, he wanted something from this board. Like, great, we'll accommodate you. So that was fine.
How's that fence building permit coming?
Still in court.
We need a fence thing to go with our porch thing.
Yes, we do. Yes, we do.
But that's, yeah.
We're lobbying, so we'll see how it goes. B and C, these are actually in the zoning code. You can't take another application. If you deny it, it's 6 months. It's statutory. So it's not something you guys can waive. Post-hearing requests, I don't believe I had any notes in.
So I have something on
Yeah,
that.
okay.
Under number 4, motions to rehear will be deliberated on and decided based solely upon filings. We have had a couple instances I know one, I'm for sure one where we did allow a hearing on whether there should be a rehearing. I can't remember which, I remember the people involved, but.
Is that a pork shade?
Carport, yeah, it was a.
Do we want to put in unless motions to rehear will be deliberated on and decided based upon the filings unless the board allows a hearing?
I think we had a deliberation though. I think it was just based on the filing. I think it was the person sent a letter in and we deliberated based upon that, but we didn't actually have live testimony on it.
Okay, you may be right. Maybe we
Yeah.
didn't open up.
Yeah, it was
Yeah,
just,
you
it
may
was
be right.
the
Okay,
letter.
well, I'm fine leaving it.
And
like
that's,
it is.
that's the intent is, they're supposed to put in writing, hey, board, not that I just didn't make a good argument. You know, I thought of something better after y'all voted no. That's not the standard. It's, here's information we couldn't have reasonably had at the hearing. Or
Yeah.
there was enough information. And y'all were fine in that case. It's just be sure that's the standard. I just tell folks who apply for these, and they're very infrequent, that understand when you submit this request to the board in writing, you've got to put your argument in the letter. You don't get to talk. This is it. So whatever you want to say, make sure you say it and that's what I'll forward to you guys. So they're being told on the front end that your letter is the only thing that speaks. You know, we've had councilmen like, can I talk? Nope. It's just his letter. You're welcome to send your own letter if you want to, or let the applicant attach your letter to his letter or her letter. That's fine. But that's all it's talking to you guys. And we'll put those just from a procedural standpoint. I'll put that at the very front of the meeting. Let's just dispense with it right now, you know, so it'll show up first case as a request for a rehearing. And it's not testimony. It's just, do you want to rehear it or not? Yep, we do. Okay, we'll set it for a hearing.
And that letter that they submit for the rehearing is not part of the new case, is that correct? It doesn't get, so if they have an argument they want to make, they need to make it again in the new case?
Yes. It's not an argument for you to grant their case. It's an argument for them to
Get whatever they're
get
seeking.
get an audience before you again, not to rehash the case.
I feel like that's probably not clear to applicants, that they have to, because I remember one applicant had some argument information that was pertinent to the case that was going to be reheard, and it didn't transfer over, so I know this happens so infrequently, but I don't think they understood.
Well, we
that.
do talk about it in 3. It's in writing, it must respect with specificity, the new evidence and the reasons for the request, not, it can be accompanied by whatever you want to accompany it with. But and it comes from, let's say y'all voted it down 4-0. The motion is intentionally coming from the folks who turned it down. So let's say it ended 4-3. 3 of y'all were for it, 4 against it. It needs to come from the people who denied it. And it's intentionally done so, like, well, obviously the three that voted for it are good with it. They need to convince one of the people opposed to it to say, okay, let's hear it again. And that's intentional in that.
What if it was a person who wasn't there? I mean, what if it was someone who just didn't participate?
You're out. Well, now, in the rehearing's brand new, it's a de novo
Right,
hearing.
okay.
Yeah, you're only voting on, in this motion, is just, should we hear it again? And the new hearing's brand new.
Yeah.
It's not, and I always caution them in sort of preliminary discussions with the applicant, like, understand, don't say, hey, Ms. Carpenter, you remember when I said this? Because Ms. Johnson wasn't there. She has no idea what she said. I mean, put on new evidence. Even if it's resubmittal of the old stuff, that's fine. Turn it back in.
Yeah, and I think that's what we got last time we had a rehearing. We got the same board packet that we got the first time. I felt like the applicant should have put new information in the board packet, for the new case, but I think the applicant probably thought the rehearing letter would transfer over to the new case. And
Yeah,
that had information.
I got you.
I think they don't realize that.
Right. No,
Yeah.
that's something that we'll have to be certain that, hey, understand, you're getting another at-bat, so,
Right, and we didn't want to see the old,
right.
The
They wanna
old
see,
information.
well,
We
it's
wanted to
fine
see
to submit
something
that,
new.
but also give them the new stuff. What's new, what's
Exactly.
changed, what's different.
yeah.
But we talked about, you're submitting the same thing again. Letter B, every person has a right to appeal to Commonwealth Writ of Certiorari, to Chancery, or Circuit, actually, Circuit's.
How does the rehearing work, though? What if somebody's case is denied by operation of law? Can they petition for rehearing?
No, because you never had you had a hearing, but it wasn't a final order. I mean, it died, so there's nothing to rehear.
Okay.
In that case, though, but they're not time barred. If it died by operation of law, they can still refile. It
Okay.
didn't die on its merits, it died procedurally.
Yeah.
So I'll bring it right back to you.
So they're not precluded by
No.
the 6-month rule?
No, 6-month
Okay.
rule for us is a vote on its merits.
Okay.
It doesn't say it specifically, but we've always applied it, it died on its merits. You just didn't have a good argument versus it died 3-2, Again, trying to give more, just equity to the person. They didn't really get a final thing. Show cause hearings are kind of spelled out here. We haven't had one of these in a long time, but they're exciting when they come back. But most folks have generally abided by what you've told them. Let's see, entry of orders. Just for you guys, I do my best to do the orders of this board the next day on Friday. Tamika or whoever's sitting back with me or Christy, they're generally trying to capture all the stuff while you're talking. And then we go back on Friday morning and watch the YouTube and go, oh, okay. And Mr. Bradford seconded that. I had Mr. Cole, sorry. We clean all that up or include your conditions on things. The only thing I'd ask is your staff, just be if you're intending to put a condition on it, just make sure it's in your motion part. If you've talked about it in your deliberations, hey, what about this? Yeah, I'm good with it, but your motion says I move to approve and you didn't include, that's not binding on this applicant. You didn't include it in your motion to approve. So be sure your conditions are with the motion. We've kind of always held it, but line out, it could be, hey, it's subject to the Planning Commission's recommendations. That's fine. You could point to it by adoption. Planning sent a list of conditions. I approve it's subject to planning's conditions. Okay, we'll drag those conditions in. But if there's something you mean to put on it, put on. What's missing in the board's rules that you don't see? We had in special exception items, daycare homes. Prior boards put conditions on daycare homes like you can't have a dog. You can't have a swimming pool. There were certain things, over the years that this board just stuck extra conditions on all special exceptions that are approved by this board will have these conditions. And you can't do that. You're not a legislative body. You have no authority to tack on rules and regulations. Now, you can add conditions to an appeal. If you see a case like, hey, I'm requiring her to have a privacy fence or no dogs is a condition of our approval. But that needs to bear out of testimony, not just we're defaulting on all these, you can't be open but from 6 to 6, Monday through Saturday. That's not y'all, that's the council's job.
Okay.
But this board had for years.
But we can
Oh, yeah.
require conditions.
Absolutely.
We've done that.
Yeah.
Okay.
Absolutely. But
Because if
what's
it goes to
happening-
the
It has to come
in
from the
protecting-
process of, it has to be case-specific
It
that we've
does.
deliberated and
Yeah.
decided that. okay.
Yeah,
And
not,
find it.
not a blanket, we had in our rules a blanket, all these conditions will be placed on every daycare home, no matter what. That's not fair to the applicant. You
Yeah.
don't have that authority, A, and B, and we never got challenged on it, so.
But we can
Yeah.
make the call that like this condition is what would prevent, an impact on public
Yeah,
safety or
absolutely.
impact to adjacent or surrounding areas.
Absolutely.
Okay.
Those are all good. Those are all fine. As long as it gives rise from testimony for that specific instance, not just everything, we're going to require X on all of these. You can't do that. But prior boards did, and no one ever challenged it. So, and I decided all that's coming out of the board's rules. If the council wants to put these in, and we've talked to council about, you're seeing a lot fewer daycare homes than this board used to see. The council's opened up many opportunities in Davidson County to do daycare out of your home without coming here. They just built those conditions in the ordinance, and
There was a bill in the legislature this session that would have removed any private HOA restrictions on home daycares if it satisfied state law.
it sounds like they're pretty serious about providing daycare for kids in the state, so.
Oh, yeah.
Just sort of the final parts, and thank y'all for taking time today. We can hold a special meeting. Y'all can call for a special meeting if you want to. There's the procedure. You're going to request of staff, hey, we'd like to hold a special meeting because we only have one meeting this month, and whatever your reason is, that's fine. There's the notice provisions. But only the business you've designated as holding a special meeting for is what you can talk about. We're not talking about anything else but the thing you told us. I can tell you from a standpoint, hasn't happened in a long time. I've got to have a place to have a meeting, so don't just pop it on me and, I may not get this room. I may not be able to get the school board. So, we'll have to work around those scheduling things. Let's see, amendments to the rules. You guys can amend these rules anytime. So we're doing it now under a regular meeting. We've talked about it. If Ann and I, in the notes you've suggested here today, we'll incorporate those and the ones you've made motions on too. And but the key part at the bottom, if there comes a question like, what do you mean by that? It's, we'll just come to you. What did you mean by X? Here, this is what we meant. That's your rule.
Hey, Joey, how do we call a special meeting without violating the Open Meetings Act if it says 3 members have to make the request to the chair?
You are essentially emailing the board's inbox requesting that.
Okay.
That's how we would handle it now. In the old days, you'd literally mail a letter to staff. You'd
Yeah.
direct it to the chairman, but you'd send it to the
Okay.
physical
I'm
property.
just curious.
Yeah,
about
that's
that.
how you would accomplish that.
And one other question while we're on that page. What's the process for a show cause hearing for initiating it? How does the applicant get do they get served or something?
Yeah, how that's happened in the past, we would send a certified letter to the applicant saying, hey, these complaints have been lodged against your use. You're hereby to show cause and hearing at this date, the board. How it works realistically is we'd get the complaint sent to us. I would bring it to you all in session. We'd put it on the agenda and like, hey, these are all the complaints we received from neighbors. Is there sufficient evidence that you wish to hold a show cause hearing? You would vote, make a motion, then I'd reach out to the applicant and say, hey, you've been summoned back to the board, here's the date. And we would handle the notice to neighbors and
Okay.
signage
And there's the service of process person in me is like there's a verification that the person.
we do it by certified mail.
Okay.
Return receipt requested, so.
Well, no, I want to make sure we don't like issue a show cause order and all of a sudden yank someone's permit and they never got proper notice
Oh,
of
no,
it or something.
no.
So
Ann will keep us from doing that. Ann will not allow that to occur. But like I said, I've had one in 25 years of staff of this board, And ultimately, it was the case that the judge finally gave him his permit anyway, so I guess they felt your show cause hearing was just so egregious that the totality of the facts was like, the judge just said, here's your permit, have a nice day. So that was a strange situation, but obviously, once you adopt new rules, the old rules are tossed. We want to incorporate to get these rules changed and filed with the clerk as soon as we can. The other ones they're a little outdated, and there's some misspellings and typos that are embarrassing a little bit. But I didn't do them, I wasn't here. So.
Should we make a motion to place the revised rules on the agenda for the next meeting? Just to approve them, or do we?
I could do, I think
What's the
our
process?
next meeting's like the 2nd
Of April?
Yeah, the second meeting in April or the first meeting in May would be the soonest we could probably get these back in front of you. We've got plenty of time to notice. We don't have to send out letters to neighbors, but we have to post it 10 days in advance on our agenda.
Right.
I think to be fair, to give us time to incorporate it.
Okay.
And do you want to see these though one more time before, do you want us to circulate them to you one more time? I think to see if we made the right edits that you all wanted. That's what I thought maybe would be the next stage.
Right.
And then you could
okay.
send back edits and maybe have it put it on like another, I don't know,
Like in
another
June,
agenda.
somewhere,
Okay.
one more
Cool.
down the road.
Are
And
you
then
going to be able
once
to
we get
send
back
us
those edits.
a red line copy so we can see?
Yeah.
That would be
So
ideal.
it would be a red
That'd be
line
great,
of
yeah.
that, of the clean version you saw
That'd
today.
be great, thank you.
And then you could all send back to me any edits on that, and then I could recirculate it, and that could be on the agenda for the next time if you want to vote on it. And even when you vote, you can always make like little edits at that point too.
We'll caption as discussion of the rules of procedure, just like we did today. We just put it on the agenda to be the last item on the agenda.
Okay.
For whatever date
Okay.
But I think we need probably a couple weeks.
So just so we can have one final discussion.
I'm sitting here
and then-
acting like I'm
Yeah.
doing it. Ann's doing it. I don't know how to do the changes.
Yeah, no, I think probably it would be useful to have one more discussion, because there were a lot of substantive issues that I think you went into a lot of detail on today, so there might be a couple things you just want to just clarify for yourselves, so, and you can also decide, like.
Council
next
might
time
try
it's
to
on-
impeach me in the interim or something like that since I'm cutting off their rights.
Well, you might decide, like, it could be on your agenda, and you can always, like, decide not to vote on it, right? And you could decide, we need, like, one more kind of go around, and then we will vote next time, something like that.
Good deal. Well, I guess that's it. Our meeting's adjourned. Thank y'all for
Thank y'all.
attending. Appreciate it. Sure thing.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.